Good morning. Good morning, ladies and gentlemen. Can everybody hear my voice? Good. On behalf of the Law Society of Upper Canada, I'd like to welcome you to today's program on the new rules of criminal procedure. My name is Pamela Lawrence. I'm the program lawyer for the Department of Continuing Legal Education at the Law Society. I'd like to take this opportunity to thank all the speakers for the time and effort that they put into today's program, which I'm sure will be of great benefit to us all. We at CLE depend on volunteer faculty, and we thank you all. It's my job to provide you with a bit of information, general information on the facilities. First of all, please respect the fact that this room is a non-smoking room. In fact, I believe Osgoode Hall is a non-smoking building. Telephones are located in the stairwell to downstairs, which you pass when you come in the east door. Washrooms are located down there as well. Please follow the signs. It's a bit of a labyrinth. We are prepared to take messages in the course of the day and post them for you. I'll give you the number if you want to jot it down. It's 947-3906. The agenda for today's program is at the front of the materials. You'll note that we have coffee and muffins, etc. out there. There's a coffee break at 10:30 and lunch is scheduled for noon. We will try to keep on schedule as much as possible. In terms of questions, I believe 15 minutes has been allocated at the end of each panel, and we would like to proceed by form of written questions. Question forms are in your binders of materials, and towards the end of each session we'll circulate and pick up the questions and forward them to Mr. Justice David Watt. One last very important thing. We appreciate your feedback very much on our programming. There are evaluation forms in your materials. Please take the time, either in the course of the day or at the end of the day, to complete the forms, hand them in to the staff when you leave. You need not sign your name. Now it's my sincere pleasure to introduce Brian Gover. Brian is currently Executive Officer to the Ontario Court of Justice General Division, and he has been instrumental in organizing this program with Mr. Justice David Watt. Thank you.
Thank you, Pam. Our program chair today is Mr. Justice David Watt, and my introductory remarks will be very brief because he is so well known to each of you. Justice Watt was called to the bar of this province in 1972, and between 1972 and 1985, he practiced as Crown Counsel and also as Deputy Director and later Senior Crown Counsel to the Criminal Law Division of the Ministry of the Attorney General. Mr. Justice Watt has a very distinguished record in both prosecution and appellate matters. Justice Watt has a great involvement in educational programs in this province and indeed in this country. And I say that because of the involvement Justice Watt has with the Federation of Law Societies program. Justice Watt has taught law school. He may have taught many of you at the University of Toronto Law School and also at Osgoode Hall Law School. As I've indicated, he was appointed a judge of the High Court of Justice in October 1985, and with merger of the High Court of Justice and the District Court of Ontario, he became a judge of the Ontario Court of Justice General Division in September of 1990. Justice Watt.
Thanks very much, Brian, Chief Justice, ladies and gentlemen. It's my privilege at the outset to introduce to you Chief Justice Frank Callahan of the Ontario Court. The Chief Justice, contrary to the belief of many of us who worked with him at the Attorney General's office, graduated from law school at University of Toronto, graduated with a BA rather from University of Toronto in 1952, the law degree in 1955, and was called to the bar of this province in 1957. He became a QC, as they then were, in 1966. I became acquainted with the now Chief Justice when he was the Deputy Attorney General of the province of Ontario, which he was from 1972 to 1977. During 77, 78, he was the Senior County Court Judge for the Judicial District of York and was appointed to the then High Court in 1979, where he remained until October of 1985, when he became Associate Chief Justice of the Court, until September of '89, when on merger he became Chief Justice of the Ontario Court. Chief Justice Callahan.
I was just noticing your time frame tonight, and my speech is already over, so that aids considerably in shortening it up. The first thing I'd like to do is thank everybody for taking the time today to come and learn about these rules. It's very important to us as a court that you understand them, and I appreciate the effort you've made to be here today, this time of year, on a Saturday morning. The rules you're going to hear about today comprehensively set out the required practice in relation to a wide variety of matters. They include the compendious rules passed by the court under Section 482 of the Code, and those made by the Chief Justice in relation to parole ineligibility reviews under Section 745. The result is that for the first time, criminal lawyers in this province have been provided with a code of practice, and it will be no longer necessary for a criminal lawyer to try and analogize his problem to the rules of civil procedure and the forms which have been prescribed thereunder. I think we're all agreed that those rules and the forms were particularly ill-suited to criminal litigation. Now, the adoption of these rules is a major undertaking on the part of our court. None of its counterparts across Canada have attempted an undertaking on this scale. We've embarked on this course because, in my view and in the view of others, there's a pressing need for rules regulating matters of criminal procedure and practice in a superior trial court, particularly one which operates in 50 different centers across the province. Ours, as you know, is the country's largest superior trial court, and it's essential that the procedures that are followed in criminal matters, whether proceedings are in Kenora or Cornwall or Timmins or Toronto or Windsor or Ottawa, wherever, it's essential that there can be no local rules in relation to the practice of criminal law. There must be a level playing field, and unity of criminal procedure across the whole province is essential. Now, the task of preparing the initial draft of these rules fell to one of our courts, and for that matter, one of the country's foremost experts. You've heard about him, David Watt. I did go to school. I did get there. I've never convinced him of that I had a law degree. Last May, the first draft of these rules was distributed to the members of our court, and afterwards copies were given to the representatives of the bar, both Crown and Defense, and comments and suggestions were received and considered, and where appropriate they were incorporated. We had many major concerns about introducing a whole series of rules into criminal practice. One of the major concerns attendant was the potential for increased paperwork for both the bench and the bar. The simple fact of the matter is, however, that since 1982, the court has been flooded and inundated with paper. It's been a dramatic increase with the charter applications, and it simply became absolutely necessary to get a handle on that increase, get a handle on the paper flow that was coming through the court. Will these rules require more paperwork? In general, I think the answer is yes, they will. But it's not paperwork for its own sake. What we're trying to do is set standards. These rules encompass those standards. And we're trying to attempt to serve the public better with our criminal procedure and trying to protect by ensuring that these the determination of criminal proceedings will be on the merits and not on some error of practice or some error of procedures. To give a practical example, the last time I sat in bail review court, affidavits were filed or tendered that were unsworn. Well, all that succeeds in doing is requiring the judge to adjourn the bail review. In some cases, the accused is kept in custody longer. Things like that shouldn't happen. What we're trying to do with these rules, therefore, is set a standard so that the lawyers across the province practicing criminal law will be under no misapprehension as to what material is acceptable in what particular type of proceeding. Undoubtedly, there are going to be costs attendant upon adhering to these rules. However, that cost will be minimized. You'll find the forms provided are comprehensive and complete. They're the best we can design at this point in time, and they don't take a rocket scientist to figure them out or fill them in. They're easy to fill in. It can be done quickly on a minimal amount of time. So we are concerned with the paperwork involved, but we believe the trade-off in a uniform practice across the province is well worth the effort. Since last May, David Watt has engaged in extensive consultation with representatives of the Canadian Bar Association, Ontario Criminal Justice Section, the Criminal Lawyers Association, the Ministries of the Attorney General and the Department of Justice, and members of our court, as well as many individual members of the criminal bar. The rules were in a constant state of revision until November 2nd, when they were passed by the court. Notwithstanding this extensive consultation, I simply want to assure you that these rules are not cast in stone. I'm committed to their continual review, and in order to ensure that they're effective in securing a just determination in every criminal case, we will keep them under continual review. We will develop whatever new procedures are necessary to meet the demands of justice. We have a court of criminal, the court has established a criminal proceedings committee. It's chaired by Mr. Justice John O'Driscoll, whom you all know. He's here today. And one of the responsibilities of that committee will be to ensure that these rules are kept up to date. Now, you'll see that Part 3 is blank. That's for a very good reason. There are many things that have to be dealt with yet. We haven't been able to deal with all of them. We are going to deal with solicitor and client privilege claims under Section 488 of the Code. Once guidance is provided from the Court of Appeal, we'll consider whether there's a need to regulate and standardize applications to exclude evidence under Section 24.2 of the Charter. We will also consider the Supreme Court of Canada's invitation to enact rules with reference to disclosure by Crown Counsel. But these are all matters that continue further study, that require further study. I think you have before you today a sufficient number of matters encompassed in these rules to occupy you and us for some time in assuring that they are properly put together and will work. I think the court over the past year has adopted several initiatives to help with the practice of the criminal law. We've introduced the criminal team system in Toronto, and I think I can report to you that we've cut our inventory in half in Toronto without any significant infusion of new resources. It's been done with exceptional hard work by many judges in the defense bar who have given us a dedicated cooperation for which we're truly appreciative. This year, we're also starting on a rewrite of our charge book. But the big thing this year is going to be these rules. We hope to implement them on May the 1st. That gives you sufficient time to study them and become aware of their implications and familiarize yourselves with the forms and how the rules will work. I ask for your cooperation on it. We've had your cooperation on everything else, and without your cooperation, these rules simply will not succeed. But with your cooperation, I believe we can bring a standard of criminal practice and procedure that's unified right across the province, and that you can go anywhere in the province and practice and know that you're not going to be faced with some local rule or local practice. Regionalization, of course, is one of the dichotomies we have to face. It carries the necessity of recognizing certain local differences. But I can tell you unequivocally, from my point of view, there can be no difference in criminal procedure in the various regions of this province. Many years ago, I had the very great privilege of working directly with W.B. Common, who was then the Deputy Attorney General of this province. He was a great scholar of the criminal law, and we spent many hours discussing it. And he used to emphasize in our discussions that criminal law, or that the criminal procedure was the imperative of the criminal law. He said that it is often the case that criminal procedure is the substance of the criminal law in any given proceedings. That's as true today as it was then. Criminal litigation is determined usually on the very fairness of the procedures that are being followed. Since the Charter in 1982 has provided us with a new challenge, and we have to ensure that the rights it grants are realized in a consistent and effective manner, I think both the bench and the bar are now coming to terms with the revolution wrought by the Charter. It's my hope that through these rules, our court will provide unifying procedures for the realization of fundamental justice and full answer and defense. We need your help on their implementation, and I'm sure we'll get it. I would simply like, in conclusion, to record my gratitude and indebtedness to the tireless efforts of David Watt and Brian Gover, who edited these rules. Their persistent tolerance and endurance in the face of my constant pushing is truly commendable. I would also like to thank all the other panelists who will be participating here today for taking the time out at this busy season to come and help us try and do something which will better the administration of justice in this province. Thank you very much, Mr. Watt.
Thank you very much, Chief Justice. The first panel is designed to discuss what are known as general matters, essentially those contained in Part 1 of the rules. The panelists to my right, Clay Powell, a graduate of Osgoode Hall Law School, a former senior Crown Counsel in charge of criminal appeals and special prosecutions, a former Assistant Deputy Minister of within the Ministry of the Attorney General in charge of criminal law, who abandoned us in 1976 to enter private practice. Is also a member of the Bar of British Columbia and a patron of several bars in the province of Newfoundland. Brian Gover on my immediate left, you've already met. Brian was a articling student at the Attorney General's office when I first met him. He subsequently was called to the bar in 1983 and has, as Pamela pointed out, been a counsel in the Crown Law Office from 1983 to 1991, when he became the Executive Legal Officer to the Ontario Court of Justice, a position which he presently occupies. And it is in no small measure through his considerable efforts that these rules now present themselves in a somewhat more presentable form than they did when I first drafted them. Alan Gold, as you well know, is a partner in the law firm of Gold and Fuerst. Alan was a classmate of mine at Queen's. We graduated from the Faculty of Law together in 1970. He was called in 1973, has held subsequently a number of teaching positions, is a prolific writer of texts as well, articles, and has participated in so many continuing legal education programs he probably can't recall the number. First of all, Alan, what do these rules apply to? What sorts of things are covered by them, and perhaps more importantly, what things don't they apply to?
Well, David, the general jurisdiction of the rules is found in 6.01 sub 1, and you see there that it applies to all applications provided for or contemplated by any federal enactment to be brought in anything other than provincial court and other than to a trial judge. So that the first thing is these rules don't apply in the provincial division. The provincial division is untouched by these rules. And secondly, the general application of these rules is to pretrial matters, not to matters that are dealt with by the trial judge. Now, it's important to note, though, that whether a matter is or is not dealt by the trial judge isn't told to you by these rules. That's determined by some external rule, either a statute or a judicial ruling. But once the other law gives you the right to apply to a judge in advance of trial, then these are the rules that you go to determine how to do that. That has certain implications. For example, the Supreme Court is developing a bad habit of always talking about the trial judge, and they keep pushing work to the trial judge. I don't think they are doing that intentionally. I think it's just that from their perspective, reviewing matters on appeal, it's natural for them to talk about the trial judge, but in any event, to the extent that their judgments are read as if they were statutes, in other words, wiretap applications have to go to the trial judge, Stitchcomb applications have to go to the trial judge, these rules won't reach those kinds of applications because they go to the trial judge. These rules are pretrial matters other than in the provincial division.
Well, Alan, what about the applications that you make at trial? Say Stinchcomb and under Garofoli, although the rules aren't applicable, do you think they can provide any help to you as to the way you might carry out some of the applications or some of the materials, if any, that you might file?
I think obviously they would for several reasons. One, the general interpretation section 1.04 sub 2 says that where matters are not provided for in these rules, the practice shall be determined by analogy to them. So that's the first thing. Based on that, you can argue they should be applied. Secondly, just as a matter of convenience, once judges are familiar with these rules, once lawyers are familiar with these rules, this is going to provide a convenient pattern to govern all applications, whether at trial as well as in advance of trial. So I think from a variety of perspectives, these provisions will be useful guides even at trial, but technically they don't as yet, although as you see there is a part yet to be written that will apply at trial. But the part you have before you does not technically apply at trial.
Clay, suppose you're not satisfied with the degree of disclosure that you've obtained from the Crown and you want to bring an application at trial under Stinchcomb. What sort of materials would you file based on the rules?
Well, that's of course the major problem is that by the time you get to trial, it's really too late to be faced with these problems in Stinchcomb. Going back a few months, I guess going back about the last 7 or 8 months, it became pretty clear that the Supreme Court of Canada was going to level some judgment on disclosure. You could get the feel of it in a case called MHC, some remarks of Madam Justice McLaughlin. Last July at the National Criminal Law Program, which David and I are co-head of in Fredericton, New Brunswick, we switched one of the panels around to deal with the subject of disclosure on the basis that it's coming. The Supreme Court, there's going to be some crusher come down. And a month ago it did, in this case of Stinchcomb. And on non-disclosure by the Crown, not providing, absolutely foolish case, I mean, so far as the Crown was concerned, not to have given the statement, but they didn't, and that's what happens in the law, and bad facts and lead to certain types of judgments. So now you have the Supreme Court of Canada, Justice Sapinka speaking for the court, saying, look, you know, this evidence gathered up doesn't belong to the Crown, doesn't belong to the police, it belongs to the people. belongs to us all in the search for justice. Now, let's suppose you're having difficulty getting disclosure, or you don't know, or the Crown doesn't know. The Crown's given you what they've got. You say, there you are, got everything we've got. There's the statements. You say, well, that's maybe not good enough. What else do the police have that might help the defense? I'm entitled to know that. I'm entitled to know the exculpatory evidence that is in the police file. And we run into a roadblock. And you try, perhaps, at a preliminary hearing. You do your best, but you're still not getting anywhere. Now you're heading on to a trial, and you really need that information to carry out this trial properly from a defense perspective. I mean, what I would be inclined to try, I don't know it would succeed, I would use these forms to bring an application for disclosure. I would have an affidavit following the forms as to what's been denied. I then would probably go to Chief Justice Callahan and ask him to designate somebody as a trial judge in advance of the trial. I don't know if it would work or not, but that's what I'd try to do, rather than be caught at the trial door, faced with the problem of trying to get disclosure and then trying to get adjournments and all those things that flow with it. So I would use the forms I'd set out in the application, what it was that I'd been denied. First of all, I think you've got to rethink whatever disclosure requests you've been making and make them very specific. Read Stinchcomb and perhaps come up with your own. I'll request all information, for and against, inculpatory, exculpatory, the whole 9 yards in a letter. And I'd send that to the Crown, fax it to the Crown, because these rules are very good in that they provide for faxing, whatever I do. And then if I didn't get back what I wanted, I'd use that as the basis for the application and to bring it on and to try to seek an order that the Crown disclose, or if they haven't got it, they go to the police and they find out about it. The other thing I might say is that I'd be inclined to start using that procedure now. The fact that these rules don't come into effect until May the 1st, I think if you're a Chief Justice, you know the work that's gone into them, and I think they'd probably be accepted at this particular point in time. That's my own personal view. I don't know that they would or not, but I don't think a court is going to be offended if you use these type of procedures starting fairly quickly.
I think there's one portion of Stinchcomb that I think we should clarify our position on to some extent, and that's this. You may remember that within Justice Sapinka's judgment in Stinchcomb, there is a suggestion that perhaps the courts ought to use the rulemaking power that they have, which we've utilized here under 482 sub 1, to make rules relating to disclosure. We don't view that, at least at the moment, as authorizing us to enact a code of disclosure. We're quite prepared, if need be, to pass rules to give effect to either a statutory mandate, in the event that Parliament were to enact, as was proposed initially by the Law Reform Commission, a new part to the criminal code dealing with disclosure. Obviously, to make that thing work, rules may be very helpful. Secondly, and it may come as a result of Stinchcomb and any cases that may come out shortly from the Court of Appeal for the province, that there will be certain matters sort of set down by judicial pronouncement that we will be able to incorporate, practically speaking, in rules which we can either add to Part 1 or include in Part 2. In practical terms, however, we're not of the view, at least at the moment, that we can create certain disclosure rights. We can enact rules to make the rights that are given by statute or by courts which bind us, but it's quite a different matter to suggest that the rulemaking power, in effect, enables you to pass criminal procedure provisions. I'm not so sure that that's so. The difficulty that we have with them, obviously, at the moment is as Clay has mentioned, is how do you possibly get this to work at the trial stage, because the trial economy and trial continuity obviously is going to suffer. And I guess if you were acting in one of these cases, the first time you would raise it, it would seem to me, would be at the pretrial conference. And at that particular juncture, you might suggest to the pretrial conference judge that since there is a matter that doesn't seem to be resolvable between or amongst counsel, that you would appreciate the opportunity, if possible, to have a trial judge designated, and whether that can be done or is another matter, to be able to deal with this in advance of trial so as not to wreck the trial process. But that's something that we're going to have to deal with ultimately, I think, in the rules. Brian, the code sometimes distinguishes between motions and applications, although the distinction is not as obvious as it was under the civil rules, or is under the civil rules, where there are different notice provisions and different material filing requirements. Do the rules draw, these rules draw any distinction, and do the civil rules have any application at all, or can we throw out the rules of practice?
Right. The answer to the first question is found in Rule 6.01, which states that where the code or other federal enactment to which the procedural provisions of the code apply authorizes, permits, or requires that an application or motion be made to, or an order or determination made by a judge of or presiding in the Superior Court of Criminal Jurisdiction, and so on. So the short answer is that these rules refer only to applications, but encompassed within Rule 6 then would be any motions as described in subsection 1 of Rule 6.01. As to whether the civil rules have any application, we must distinguish between the existing Rule 2 of the rules respecting criminal proceedings, subsection 1 of which stated, or still states until May 1st, where no other express provision is made, the rules of civil procedure with respect to applications apply with necessary modifications to proceedings under this part. And accordingly, that must be contrasted with the provision that Alan has referred to under the new rules, Rule 1.04 sub 2, which states that where matters are not provided for in the new rules, the practice shall be determined by analogy to them. So the short answer is that the civil rules have no application, or will have no application, on May 1st of 1992. However, a point is made in the handout, and that is that some of these rules represent a reproduction of civil rules, and to the extent that that is so, the handout is fairly clear as to what rules are identical to the civil rules. And in those instances, counsel would be well advised to refer to one of the annotated annual practice books in order to find out what the judicial determinations have been so far in connection with those particular rules.
Alan, suppose you're acting for an accused, and your retainer is complete at the conclusion of the preliminary inquiry. What obligations does the then accused have, if any, under these rules, the person who acts on his or her own behalf, and how do you make sure, from your point of view, that you're not required to receive service of documents after the preliminary, after your retainer's expired?
Well, here I think it is important to read the rules carefully, because first of all, it's important to note that these rules apply to unrepresented accused. Obviously, I think judges would not hold an unrepresented accused to the rules quite so literally, but in theory, an unrepresented accused does have to comply with all of these rules. That may be important to you if you go on for an accused after certain things have already been done. You'll have to tidy up any breaches of the rules. But one of the things that concern me is if you look at the definition of solicitor of record in 1.03, the definition section, says solicitor of record means a solicitor who represents or represented the accused in the proceedings which are the subject of the application or the appeal. Now, it may have been forgotten, but if you go to the criminal reports way back when, there's a practice direction from several decades ago that if your retainer is only good to the end of the preliminary hearing, you should say that at the end of the preliminary hearing. You put it on record saying my retainer is now exhausted, because otherwise you're on record for the trial proceedings. And we've sort of forgotten that. This concerns me because this has the potential to involve you in things like service and obligations to the court as a solicitor of record, even if your retainer is exhausted. As you know, the judges haven't the slightest interest in your retainer and whether it's healthy or on the critical list or whatever. If you're counsel of record, you have obligations to the court that you're expected to fulfill. Under these rules, it becomes very, very important that you develop the same sensitivity that American lawyers have to being on the record and getting off the record if it's appropriate. Now, one of the applications in here is an application to be removed from the record, but that applies when you need the court's permission to get off the record. You have to be aware of the fact that in other circumstances, your retainer is exhausted, you're entitled to be off the record. You don't need anybody's permission. For example, at the end of the preliminary hearing has traditionally been recognized as a point in time when you can simply announce that you're no longer acting, and you don't need the court's permission to do that. I don't know why historically it's been recognized as such, but it has been. So that my advice is that when there is a time when you are no longer acting, file a piece of paper. Serve and file a piece of paper. In other words, it's not an application to get off the record, it's notifying the court that you are no longer acting. For example, if the client discharges you. That's another obvious example where you have no say in the matter. The client has discharged you. File a piece of paper. Otherwise, under these rules, as I say, you, for certain purposes, remain solicitor of record and can wind up being served with things and having obligations to the court which you really shouldn't have or wouldn't want to have. And you just got to keep your status on the record clear at all times.
One of the rules that I think some people may bank on a little too heavily is Rule 2, and although I can see it being exercised, as Alan has mentioned, to perhaps relieve an in-person accused of certain obligations which he or she may have difficulty complying with under the rules. Rule 2 does give a general dispensary authority, but only where and as necessary in the interests of justice. A judge in proceedings to which the rules applies may dispense with compliance. I would not, however, invest too heavily on that rule. Don't get the impression that that there's going to be some blanket dispensation granted on a regional basis, for example, that you won't have to file factums in summary conviction appeals in the Northwest region, because that's not what that rule is intended to cover, and I don't expect it to be interpreted that way. It will be used as the exigencies of the situation require. It's handy for you to know in the event that non-compliance is not possible, but by the same token, it is not something that you should, as a solicitor, expect will be exercised in your favor as a matter of routine. One of the areas, of course, where difficulties sometimes arise is with respect to extensions or abridgments of time. And Brian, maybe you can help us. Can you get an order abridging or extending time under the rules? If you can, when do you get it? Who do you get it from? Do you have to go there to get the order? What sorts of things do the rules permit to be done?
All right. These matters are addressed in Rule 3.02 of the new rules, which provides that an order abridging or extending a prescribed time for doing things may be obtained before or after the expiration of the prescribed period. Such an application, or such an order rather, may be obtained from the court, and consent may be given in writing pursuant to Rule 3.02 sub 3. Now, as for whether a formal court attendance is required, it appears that no formal court attendance will be required. It's interesting to note, however, that the words "without the attendance of counsel," which are included in other consent provisions in the rules, do not appear in this consent provision. But in my view, by referring to a written consent, we are obviating the necessity of attendance by counsel.
Any comments, Clay, about that sort of abridgment, extension of time, or generally?
Just generally, David, in relation to the following of the rules and your indication that you shouldn't put too much hope in that effective non-compliance. As one of the draftsmen, I'd go back to Rule 1.04, not me the draftsman, you the draftsman, are certainly involved with it. These rules are intended to provide for the just determination of every criminal proceeding, shall be liberally construed to secure simplicity in procedure, fairness in administration, and the elimination of unjustifiable expense and delay. I'm just curious how you see that section, the purpose of that section, and how it might, we might rely on that for some lack of compliance.
Well, certainly it is inserted there as an interpretive aid to the judge determining the scope that the rules provide. It is not there for the purpose of ignoring them, obviously, but it's another factor that the judge can take into account in determining whether or not compliance, first of all, has been made, and secondly, if not, whether this is a case in which some relaxation should be granted. For example, there may well become situations of some urgency where in practical terms notice provision is going to have to be abridged. And you would call in aid in those circumstances the general authority to dispense with compliance, as well the necessity of determining matters expeditiously, fairly, and eliminating any unjustifiable expense or delay. Sometimes counsel unreasonably insist on notice provisions, usually respondent's counsel, and this particular provision, together with the general authority to dispense with compliance, where no prejudice is created to either side, can be invoked to relieve against some harshness. Brian, you're probably a little closer to this than the majority of us are. The documents that get filed, the forms require a court number to be put on them. Are there any proposals or suggestions that you have as to how you get a court file number? I can recall a few years ago trying to get a court file number from Weekly Court. And
Have you gotten it yet?
no, it's in the mail, I'm told. how do you think we should handle this? Because I think there may be some practical things that we can do from the point of view of the court to make life a little bit simpler for you.
Well, a court number is required, and what is envisioned is that a unique court number will be assigned to each indictment, as is currently the practice in Metropolitan Toronto. The court staff will be instructed as to the issuance of numbers, and what we will strive to achieve is simplicity for counsel in obtaining those numbers over the telephone through the most expeditious means possible. These rules, after all, and these forms were designed to get around the cumbersome procedure, in the case of applications especially, of having the form issued by the court. And through requiring a court number, all we're endeavoring to do is ensure that documents are filed with the appropriate material accompanying them. And we will address that problem simply by instructing court staff as to the simple means of assigning court numbers to documents.
I think the difficulty that many of us see at the moment, or many of us find at the moment, is that half the time you don't get the materials that you're supposed to get because they get put in some other file or somebody else looks after them. Whereas if there's a single number, the indictment number that's assigned to a particular case, then all proceedings in that particular case, whether it's an application to vary the bail, or whether it's an application to change the venue of the trial, whether it's an application to get some exhibits for scientific testing or whatever, then goes to that particular file so that it can conveniently be located, and hopefully the chances of it being lost, mislaid, shredded, or otherwise are hopefully minimized. I'm not suggesting that they'll ever be non-existent. As long as humans embark on the process, they will get lost, but we'll try our best to make sure that everything gets in the same file.
I just wanted to ask one thing on that, David. Bail reviews, for instance, there wouldn't be necessarily an indictment at that stage. I can remember years ago when Fred Hayes was the chief judge in the provincial court going back into the 70s. He desperately tried to bring in a system that every case that came into the system had a number starting out when the initial information was laid, and that stayed with it on through. It could never be sold, I guess the cost of computers, equipment, and everything at that time. But I understand what you're trying to do, but that you don't envisage it being a number that's carried forth from provincial court and sticks with the case all the way through?
Brian?
No, we don't. What is anticipated in connection with bail reviews is that a dedicated number will be assigned, and in the event that an indictment is filed subsequently, it will receive that number, but we will not somehow fail to assign a number to bail review documents simply because there's no indictment in our court.
Same thing. Hopefully will apply, for example, where the first proceeding that we see is a motion to quash the committal to stand trial, or some document that might predate, or procedure that may predate the filing of the indictment itself. Speaking of service and filing of documents, Clay, you mentioned dealing with filings or service by fax. Is there only one method of service, or do some things apply to some methods of service apply to certain types of proceedings, and others apply to others? What do the rules provide about method of service and filing of documents?
Well, Rule 503, for example, Rule 5 generally deals with service. Start with 501. Notice of application that includes an application for prohibition shall be served personally, say on the judge. And then if you look at personal service, defined in 502, were documents to be served personally, and under C, on a judge or justice, it's by leaving a copy of the document with the judge or justice or with a person in charge of the court office where the adjudication was made. You'll see throughout these rules, usually there's reference to leaving documents with the court services manager. And I'm assured that now in each court there's such a person. I didn't know that, but apparently that's a new position that now exists. Just dealing back with 501 on an application that includes prohibition, all right, they want personal service. Used to be a problem, you know, on service or prohibition on judges. Some judges used to get very angry. You'd hand them a motion for prohibition. Don't hand me documents, go another route. But so you can leave them with the person in charge of the court. Then it goes on and says that service, and you'll see at the end of 501, you can also be made on the person in charge of the place where the applicant or the respondent is in custody. I assume those are matters which would have to do with the lawfulness of the custody itself, that you could go and serve the jailer. Then there were various sections dealing with the type of service, but it would appear at Rule 505, for instance, service of a document on a solicitor of record of a party may be made, subparagraph D, by telephone transmission of a facsimile of the document. And I believe in the cases where the Crown can serve you as solicitor of record, as someone who represents or represented, as Alan pointed out, you get something through your fax machine saying, we used to act for this fellow, and you're now, here's your notice, be in court on a certain day. That could be a problem, but it would appear that likewise that service can be made on the Crown in nearly all matters by fax.
Well, the one provision that you should note, because I assume that the majority of you would be acting on behalf of an accused rather than on behalf of the Attorney General, is 5.01 sub 3, where the Attorney General is an appellant, as for example in summary conviction proceedings. Either the Attorney General, his or her agent, the informant, or any party other than the accused, essentially, who is initiating summary conviction appeal proceedings, then the rule is personal service of the notice of appeal on the accused. But the object of the rest of the rules is to permit, at all possible, and to encourage, in most cases, documents to be served on the solicitor of record. For example, as you'll see subsequently, application records, factums, those sorts of things. We didn't think it appropriate to be served on an accused person. Rather, to serve them on the solicitor acting on his or her behalf in the majority of applications that will be dealt with by these rules. Alan, from the point of view of defense counsel, I would take it that, assuming that there's no difficulty with you continuing to represent the accused, do I take it as defense counsel you would prefer to have the majority of documents relating to the types of matters that are dealt with by these rules served on you rather than on the accused?
I think that's true, just to avoid conversations between the accused and whoever is serving the documents on him or her. Generally, that's true. The only time it wouldn't be true is if for some reason you thought there might be a difficulty locating your client and you're sort of trying to manufacture a fortuitous problem with service that might otherwise provide a defense. But generally, it's certainly our practice to accept service on behalf of a client for that very reason, that otherwise the client will engage in conversation with the server.
Used to be actually quite a good way of ensuring that there was no dispute about voice identification in wiretap cases. would be to have the officer engage the accused in some conversation at the time that the documents were served on the accused, and then voice identification subsequently became somewhat of an academic issue. You have to point out, of course, that this is a transcript, and this is like where your name is here. That's where you said to, you remember that? And then the assertion that, well, that wasn't my voice, tends to lose a bit of its impact before the trier of fact subsequently. How do you start these applications, Alan? What paperwork do you have to utilize generally to get an application underway, and where do you make the application generally?
Well, this is one of the great mysteries, to my mind, is scheduling. The rules set out all the documents and the content 6.01, and it tells you, it gives you a Form 1, so it's very simple. It's filling in the blanks, and these forms are all great because they're all right side up. There's no sideways forms like in the civil rules anymore, which I think is a good step in the right direction. And now, in terms of when they're heard, I've been through many changes. It used to be once they were heard every day of the week, then they were heard only on Tuesdays, then it was Tuesdays and Thursdays. I honestly don't know the current practice, what day of the week these are heard.
I hear them, and I don't know either.
I know that somehow, in a miraculous way, they get heard, and often if it's an emergency or a problem or something, someone in my office, I don't know whom, speaks to somebody in some other office, I don't know whom, and I'm told to show up at a certain place at a certain time, and somehow the court office generally accommodates all these requests and things miraculously get done. The rules, unfortunately, don't deal with scheduling in that. I think there was some thought that the motions are heard on Monday. I never liked doing motions on Monday. Why? Because the days before are holidays. I've always liked Tuesdays as the best days because Mondays tend to be busy for the courts from the weekend work. And also having a working day the day before is great because it gives you a chance to talk to the Crown and sort things out. Monday morning applications where you haven't had a chance the day before to speak to the Crown, I don't think are efficient for everybody, the Crown, the court, defense counsel. Now, it may be that in keeping with government policy, courts in Ontario will now remain open the 4 Sundays up to Christmas for any last-minute judge shopping, but I don't know if that's definite yet.
Brian, can you comment on the scheduling and how it's anticipated that will be handled in the various jurisdictions across the province?
Certainly. It is anticipated that criminal trial coordinators will be responsible for scheduling at the direction of the regional senior justices. Here in Metropolitan Toronto region, it is Liz Aiello at 361 University Avenue. And counsel would be well advised to let Liz Aiello know of any problems that they're encountering in terms of limitation periods. For example, the solicitor-client privilege determinations under Section 488.1 of the Code place certain duties upon counsel to act within, I believe it's 15 days of the seizure being effected. And it would be good practice on the part of counsel to advise the criminal trial office of any difficulty with such periods.
The general provisions of Rule 6 indicate that the applications are to be made to a judge of the court in the county, district, or region in which the trial is being or is to be held, unless otherwise directed by the Chief Justice or a judge of the court designated by him or by her, or unless otherwise provided by the rules. So the intention of the rules is to keep proceedings relating to cases to be tried in particular jurisdictions in those jurisdictions. There's less of a practice now than there used to be of bringing applications, for example, for extraordinary remedies into metropolitan Toronto rather than in the judicial district or region or county where they arose. The intention of the rules is to keep those proceedings at all events within the region. Now, it may be that you will find that there will be practice directions given by the Chief Justice, as the rules permit him to do. They may be applicable to all regions or only to some. And it may be that you would, if practicing in a region other than metropolitan Toronto, be wise to determine whether there were different dates on which these applications were heard, or different days of the week than in metropolitan Toronto, because the purpose, quite frankly, is to allow a sufficient degree of flexibility as to the days of the week on which they're heard to allow for regional variations. It may well be that in the Northwest region it is appropriate that these particular applications be heard in the judicial center of the region, where distance is perhaps a greater concern than it is in some of the regions that are a little closer together in the southern portion of the province. But you may take the basic rule to be that you bring your application where the proceedings are going to be dealt with at trial, and any application relating to it will be there. You commence the applications by notice of application in Form 1, which is included at the back of your materials. It's a very fundamental sort of document saying what you're looking for, why you want it, what you're relying on in support, and whether or not you need an order extending or abridging time. The notice provisions have been helpfully summarized by Brian in some material that you have to supplement the rules themselves. And you will notice that the basic rule is that applications consist of two documents: an application record, a factum, and then any supporting material that may be necessary. The individual rules, however, as you will come to see, may dispense with factum requirements. Alan, from the point of view of defense counsel, leaving judicial personalities aside, would there be any type of case where you might want the application heard out of the county or district or region where the trial is likely to be held? Can you think of any offhand where you might want to get the application heard someplace other than the region where the trial is scheduled to be held?
I think the most common one would be a change of venue application, which is often heard in a separate jurisdiction to prevent additional adverse publicity. Beyond that, it would probably be pretty unusual particular situations that are hard to generalize in advance. But just before we go on, there's one thing I want to point out, because I didn't know this. I know it now from our meeting, but the one thing Brian was going to tell you that may not be clear is that the return date for an application, you don't just pick it. You do have to phone up in advance and get a return date.
That's right. Court staff will be instructed to provide return dates just over the telephone to counsel. And the point is to ensure that there is court time available on that date for the hearing of the application. And as I indicated, court staff will be instructed to make special allowance for those cases where counsel are running into some difficulty because of a period prescribed by statute.
Brian, can I ask you to switch back to your Crown hat now? And we know that the application record and a factum, generally speaking, is required on applications, and obviously supporting material in the form of affidavits. What does the respondent have to do, if anything? Do they have to file any of those appearances, saying the Attorney General shall appear and answer to this, or have we gotten rid of that?
It was thought to be inappropriate to require the Attorney General in a criminal proceeding to file a notice of appearance, with the injunction at the bottom of the form, of course, that if no notice of appearance, this was the old notice of application form, if no notice of appearance was filed, then a judgment may be entered in the Attorney General's absence. As for respondent's material, you'll see that Rule 6.05 sub 3 refers to a respondent's application record. Now, this may or may not be required. It depends on whether counsel for the respondent is of the view that the material is in some way deficient. And this gives express authority to responding counsel to file a record on behalf of the respondent. And Alan has referred to the factum requirement. Factums are required from the respondent where required of the applicant, of course, and these factums are in the standard four-part format, now in use in the Court of Appeal, and with which many of you will already be familiar.
Brian, lest anyone start to be concerned about the factum requirement being wholesale, could you give us some indication as to the types of applications, the specific types of applications where factums are required? I know we'll deal with them, other panels will deal with them subsequently, but could you give us a brief rundown as to the requirements of filing factums on specific applications governed by Part 2?
Certainly. It may be handy for you to refer to the table set out at page 6 of the summary, and you'll find, for example, that on applications for judicial interim release or bail review, no factum is required. You'll see that factums may be required in the discretion of the judge in relation to applications for release of exhibits and application for removal of counsel of record, that no factum is required for an application to procure the prisoner's attendance, and that factums are required, as they currently are for that matter, for applications for change of venue, an application to take evidence on commission, and an application raising a constitutional issue.
You will see as well subsequently when you deal this afternoon with extraordinary remedies and summary conviction appeals that factums are required in those cases as well. Now, the difficulty that there is in many instances in these applications, in my experience, has been caused by the inadequacy of the record that you're dealing with. The primary responsibility for the completion of an adequate record lies with the applicant, not with the respondent. The respondent is entitled, under the rules, as Brian has pointed out, to supplement the applicant's application record. But you must bear in mind that the primary responsibility for the completion of an adequate application record rests on the applicant. It is, after all, his or her application, and it's only appropriate that that be the case. The respondent may supplement what there is with materials that he or she may file by way of a respondent's application, but generally speaking, we look to and expect the applicant to have a complete record present so that we can make a determination based on it. Now, in addition to the application record and the factum, and the rule which relates to it is Rule 6 in its various sub-rules. But one of the matters obviously of some concern is what additional material, how does the judge make the determination of the issue? What material do you have to file? Well, you'll see that evidence on applications is governed by Rule 6.11. Alan, could you help us as to the types of evidence that may be received on applications, and from the point of view of the defense, do you see any advantage over using one method or the other, or sometimes would a combination be what you'd be looking for?
I think in general the three types of evidence are affidavit, viva voce, and under 613 there's sort of express recognition of agreed statements of fact. Now, with regard to affidavits and viva voce evidence, you'll notice that 611 sub 4 and 612 both say subject to the code or any other applicable statute or rule of law. So that ensures that the ordinary rules about compellability in that from the point of view of the accused still apply. But having said that, if you file an affidavit, sub 4 now contemplates either cross-examination at the special examiners or viva voce on the hearing. And then 612 is dealing with evidence both in chief and cross-examination viva voce at the hearing. If it's a delicate witness, such as an accused or someone closely connected with the accused, quite frankly, I think you're better off not filing an affidavit in advance, because then the Crown would be forced to just listen to the evidence and cross-examine on the spot. And you know, forewarned is forearmed, so you don't want to forewarn the Crown. So witnesses like that, I'm not keen to file affidavits in advance, especially when they could then be cross-examined at the special examiner. With regard to that, bear in mind that although that may be convenient for the court to have the cross-examination done in advance and read a transcript, if your witness is a good one, you'll lose the benefit of the court seeing your witness as well. There's going to be expense involved. If it's a legal aid matter, you'll have to sort those things out. The other provision that has the potential, I think, to do a lot of good is the agreed statement of facts, because oftentimes, at least I find, there are things that really aren't in dispute, but the Crown doesn't want to necessarily agree because they're not sure whether they're giving up any tactical advantage or not. You know, you could send them over an impressive document headed, you know, proposed agreed statement of facts pursuant to 6.13 of the criminal proceedings rules, and say, you know, I propose that these be agreed facts. And if nothing else, when you walk in on the hearing and you explain to the judge that you've got to spend a half a day calling evidence now because the Crown won't agree to these facts, which the judge will then turn to the Crown and say, well, are you disputing them? And the Crown will hem and haw. I mean, it's a good tactical advantage. So bear in mind that you can kind of, as civil lawyers do, use that provision to try to put your opponent in a tactical position where either the opponent agrees to things that probably should be agreed to for other than tactical reasons, or else perhaps might incur the displeasure of the judge, who then has to listen to evidence in place of agreed facts. Of course, any proposed agreed facts coming over from the Crown to you are simply filed in the appropriate place. If it's not in your client's best interest to agree to them. I hope I've demonstrated my usual fairness and even-handedness.
Clay, from your point of view as defense counsel, would you have any particular preference for a method of getting the facts before the judge hearing the application? I know as a prosecutor, you once conducted the better part of a case on the basis of an agreed statement of facts. Did you want to follow that approach as well, or do you see any advantages to doing it another way?
Well, for the purposes of motions, I think that agreed statement of facts are a very good way to go if you can. I've had an unfortunate experience in relation to agreed statement of facts in relation to trials recently, which has caused me to rethink my position anyway in that regard. I think that points Alan raises, particularly about this right to cross-examine before a special examiner, I envisage real problems. I mean, there's always been the right to cross-examine on an affidavit, as I understand. But you put an affidavit of the accused in. I know we're not dealing specifically here with charter motions and things like that, but you get a notice to attend, and as Alan says, the cost. Who's going to pay for this? I understand, I've had no personal experience in this, that if you as defense file an affidavit and the Crown cross-examines, the Crown takes the position that you pay for the cross-examination because you filed the affidavit. I've been told that by some people who've had that experience. I don't know. That's something that would have to be clarified.
Brian, from the point of view of the prosecutor, if you want to file additional material, any preference, or call additional material on the application, any preference, whether it's affidavit, viva voce, what about agreed statement of facts?
Well, I think that agreed statement of facts present a means of providing the tribunal with an evidentiary basis that prosecutors simply haven't made adequate use of yet. There's always the fear that the other side is trying to pull a fast one. And from my point of view, I would like to put the evidence before the court in the most expeditious means possible. And I also think that that's simply good counsel work.
One of the difficulties in the past with respect to cross-examination and affidavits has been that when we did criminal motions at Osgood Hall, there was no place to cross-examine somebody live. They didn't have witness boxes or at least and/or court reporters available. That's less likely to be a problem, I suspect, now under the present scheme, because the majority of times we're hearing these types of applications in courtrooms where there are witness boxes and there are court reporters available who can take down the proceedings, so that the record-keeping part of it is less of an obstacle now than it was before. From the point of view of a judge presiding on these applications, it in some instances may well assist the resolution of the case to be able to observe the cross-examination or the leading of the evidence in its entirety. It's very difficult in cases where there are conflicting affidavits and simply transcripts to look at of examination of the affidavit thereafter the cross-examination to make any findings with respect to whom you believe. And it's impossible to do it. The Court of Appeal mentioned it in Jetco Manufacturing, and it is absolutely critical for a just determination where there are controverted issues of fact to be able at least to observe the witnesses. So there's that advantage to it from the point of view of the tribunal that decides the case. I don't want you left as we break with the impression that we're talking about agreed statements of fact in a lot of cases. For example, many of the applications are simply not conducive to it. For example, bail review applications obviously are going to be dealt with on the basis of the transcript of the show cause hearing, any other review hearings, and that sort of material that we conventionally see in properly prepared applications. What we're speaking of here are applications where there are some requirements of getting evidence before the court that doesn't arise from earlier proceedings, and it's on that basis that the forms available are affidavit, viva voce, agreed statement of facts, or the combination of the three. Now, we've run slightly over time. We didn't have the opportunity to deal with some questions. If you have them and have written any out, we will endeavor to work them in through the remaining panels during the rest of the day and have them answered at the conclusion. Thanks very much.